next matter coming before the court is in re GRZ and CRZ. Mr. Medbeck, you have 15 minutes for this to present oral argument. We have read the briefs, so we're ready to see what you want.
Thank you very much. Good morning. May it please the court, I am Alan Medbeck. I'm here on behalf of the appellee and cross appellant, Ms. Richard Zentz, and now Ms. Klein. So I refer to Ms. Klein throughout this. I'm referring to the appellee in this matter. We are here on a challenge to a custodial ruling out of the juvenile court regarding two children that were conceived during a cohabitation between the parties. The hearing that was conducted was a legal custody hearing, and the outcome of that was that custody was to remain with my client. The factors tried before the court, because this was a non-parent relationship, it is a same-sex relationship that predates the Obergefell decision. I probably said that right. So the issues before the court were whether there was a contractual, whether there was a relinquishment by my client of her parental rights as a biological parent to the non-parent in this matter, and whether it would be in the best interest of the children that they have a relationship, that custody be changed in this matter to include the non-parent, Ms. Zentz. At the trial, Ms. Zentz presented evidence of testimony from Ms. Klein on cross, the father, Mr. Antleberry, as on cross, and from a supervisor at the Common Ground facility, Ms. Whitaker. The outcome of that finding was that there had been a relinquishment through a settlement agreement, and that, however, it was not in the best interest of the child, that there had been insufficient evidence presented that the children should be placed with Ms. Zentz. Ms. Zentz challenged the finding, and I want to be clear as to what it is she challenged. She did not challenge the insufficiency finding. She is here solely claiming that there had been no best interest factors presented, that was not a part of the hearing. I think that the record makes clear that that is not the case. That the factors of best interest were clearly before the court. This was always styled as a legal custody hearing. The findings for legal custody requirements in this situation are that there be both a relinquishment and a finding of best interest. There was very little confusion on that, and if there was any confusion, that was clarified by appellant's counsel herself in an exchange with the trial court when Mr. Antleberry, the father, objected to admission of evidence on a basis that it was irrelevant to the contract relationship. Ms. Leslie stated, when inquired, and the judge asked specifically, can you tell me legally why best interest is an issue in this case? And trial counsel responded that correctly, that unsuitability of the non-parent, that unsuitability of the parent was not the only issue, but suitability or best interest of the non-parent must be shown as well. And the judge overruled and Mr. Antleberry's objection based on that argument. So Ms. Leslie and the appellant clearly understood the nature of hearing that date. Again, on page 59 of the transcript, you will find that the court again overruled Mr. Antleberry based on regarding the testimony of Ms. Whitaker as irrelevant to the contract relationship, and that was upheld specifically when the trial judge stated, but it does have to do with the best interest factors. So that issue is clearly understood to be before the court. It was understood by all parties, including Ms. Zentz and her counsel. The court's finding that it was insufficient is, I think, upheld. There was the only testimony regarding the current state of, there was no testimony giving regarding Ms. Zent's housing, regarding her income, regarding her ability to meet the basic needs of the children. That is a finding it is unchallenged here, that evidence was not presented. I think that is clear in the record. Ms. Whitaker's testimony in its entirety could only have been presented to speak to best interest.
Why? Why would that be?
Because as a supervisor at Common Ground, she would have had no knowledge, no interest, no involvement in the contractual agreement between the two parties, between Ms. Zent and Ms. Richards. And there's absolutely nothing else to speak to in that regard that could speak at all to the nature of their contractual obligations or any relinquishment of a parental right. That was not discussed or presented in any way in that evidence. So that here on appeal, it's disingenuous to argue that there was some misunderstanding as to the nature of that hearing, or that it was to be limited to bifurcated. There's no motion to bifurcate those issues. At the start, there was a request for any pretrial motions. It was understood there was inquiry regarding that issue. I think the best interest finding, the judge did not abuse her discretion in making that ruling. There was no need for further evidence on that. The plaintiff, the petitioner, the appellant presented her case as she saw fit. She did not present Ms. Zentz herself to testify regarding either the contract or the best interest factors. I think that matter stands on its own. I think that there is no abuse of discretion in that. Regarding my client's cross appeal and the finding that my client had relinquished at least some portion of her parental rights, I think that you will find that the testimony is uncontroverted and unequivocal that even during the relationship and at the time they were discussing having these children, that my client was always to retain legal custody of the children. She states that there was in her testimony that there was always an understanding, even when in the relationship, that she was going to be the custodial parent, the legal guardian, and the person with all legal authority in that matter. That has been true throughout, and I think that even the document itself, it doesn't use terms, and admittedly I don't believe this was drafted by attorneys, and maybe the terms are inelegant, but the terms used are not residential or non-residential. They are non-custodial and custodial. It's speaking to what I believe they understood to be a custody relationship. The court found that, and I'm not quite sure how, that some parental right had been relinquished, and I think that she latches onto the use of the word parent in that agreement, and that can be the only thing that I point to. And I say that is controverted in the Mullen decision, which that's contradicted, which finds that the use of the term co-parent throughout all the documents in that agreement are not sufficient to create a relinquishment of a parent right or a shared parenting agreement of any kind. There is nothing to indicate that the contract presented was not revocable, that it was not simply an agreement to provide for visitation privileges and support obligations in a quid pro quo contract manner, but at the discretion and agreement of the custodial parent, which is Ms. Klein. I think that she has stated throughout, again, that she had no intention of relinquishing that, and to do so by accident, simply by use of the word parent, I think is far-fetched. The cases that predate this, and again, this predates right to legally marry as a same-sex couple. So some of these issues are resolved, I'm hoping, at this point, going forward. But right now what you're faced with is the Mullen decision and the prior, I think, Boddick decision, out of which there are two issues on this. The Mullen decision, I think, speaks to post-breakup actions, but the court relies on the earlier decision, which was the act of a same-sex couple approaching the juvenile court to enter into a shared parenting agreement. They've told they couldn't have a shared parenting agreement, but a shared custody agreement would be viable. And they sought that to, I think, avoid these, to make a legal determination before the fact and have the court enter into that irrevocable relationship. The Mullen court, more similarly to this case, was a motion to attempt to enforce what were revocable acts after the relationship had deteriorated and ended. I think that there were means, I think there was a means of going through this process to, if Ms. Zenz had sought it beforehand, to obtain those rights, and the parties could have entered into that relationship, and that relinquishment of parental rights in a irrevocable way, while they were in the relationship, they did not do so.
What would have been the additional steps they could have taken to enter in the type of relationship?
And bear with me just one moment. The additional steps that they could have taken would have been to approach the juvenile court, as in the Bonfith case, and I apologize, that is 97 Ohio State 3rd 387, where the cohabitants approached the juvenile court to enter into a shared custody agreement, and that was upheld, and that was finding a document that the court could issue and find that shared custody agreement was binding and in the best interest of the children. That could have been done while they were in the relationship, at that point, as a shield to the non-parent. Here, I'm sorry.
So in that case, they would have, before they decided to split up at all, they would have had to go to juvenile court as
And
as a non-parent.
that I think is the finding, the takeaway from the combination of the Bonfield and the Mullins case.
So they would have had to file their
That I think they-
juvenile court first.
I think that is the, I'm not going to say have to, but I would think that is the appropriate way to have done it, and that it would be the more secure way to reach that conclusion, to reach the end that those parties may have wanted at that time, to make that clear. In this case, the testimony at trial was that Ms. Richards never intended to relinquish her custodial right, that she was always going to be the legal custodian, and that would explain why they did not approach this.
So it'd be sort of like a full faith and credit, asking this state to enforce another state's stuff, or asking this court to enforce an agreement that these people came to.
Well, if it had been an enforceable, if it had been entered into by the juvenile court, the terms of that, it would had legal authority behind it. And I think at that point, right now, what we have here is a contractual agreement that was almost immediately breached in terms of the support right, the support obligation by Ms. Zenz. And the recourse at that point after breach would have been revocation of the contract. And that would include if the quid pro quo was, and I hesitate to reduce a child parent, or I hesitate to reduce persons to commodities, but termination of the visitation right would have been the revocation. That would have been when the contract was breached and the support payments were not made, the contract was invalid, and that was conducted by that invalidation was by Ms. Zenz. Beyond that, and I think that the father's attorney at trial brings up an analogy to a visitation center, to where if there's a daycare, if there's some unrelated non-parent who has a right to watch the children, the parent has a right to revoke that right if he believes that it's not healthy, if he believes it's not, if she believes it's not in the best interest of those children. She has that authority, and I think that's where we are in this case, that,
And counsel, I need to inform you that you do less than 15 minutes of your allotted time today.
I appreciate that, and I thank you for your time.
Thank you for your presentation this morning. Court will take the matter under advisement. We will issue a written decision which we now tell both sides.